So we're ready to start the next panel. This one, as I mentioned at the end of the last one, is going to be about AI and chatbots in the law. And so our moderator for this panel is Andrea Smith, who is a senior lecturer in law here at the NDSU College of Business. So Andrea, please take it away.
Sounds good. Can you hear me through this mic? We're all good. So I am Andrea Smith. I am a faculty member in the College of Business, also a Challey Institute Fellow. And as the moderator of this session called AI Chatbots in the Law, Language Models in the Law, I'd like to first introduce and give a little background on our panelists. And then I'd like to invite questions from the audience after they have a little bit of time for their remarks. Now, I know Dr. Straub has been on stage quite a bit of the day, but for those who are just joining us, I will do a brief intro of Dr. Jeremy Straub. He is a fellow at the Challey Institute for Global Innovation and Growth. He's an assistant professor of computer science at NDSU. His research focuses on the intersections between technology and policy in both AI and cybersecurity areas. He's the lead inventor on 2 US patents and has published over 50 journal articles and hundreds of conference papers. And next, I would like to welcome and introduce Professor Nikola Datsov. He teaches courses in intellectual property, torts, remedies, and conflict of laws at my alma mater, University of North Dakota. His research and scholarly interests relate to AI, patent subject matter eligibility, and the intersection between technology and different areas of intellectual property law. Prior to law school, he worked as a computer programmer and technology consultant. Before entering academia, he practiced law at a firm in Minneapolis, focusing on his national practice in intellectual property litigation, AI, and anti-counterfeiting. In his practice, he litigated high-stakes cases in federal courts throughout the country and represented parties before the Patent Trial and Appeal Board, successfully challenging numerous invalid patents. Professor Datsov earned his Bachelor of Science in Computer Science from the University of South Dakota and his JD from Hamline University School of Law. Thank you both for being a part of this panel. And Dr. Straub, may we start with your opening remarks?
Absolutely. So, I think this is we obviously had a lot of really neat topics today, but I think, the question of AI chatbots in the law is really one of the most interesting ones that we have, because there's so many aspects to it, right? So, you could start from thinking, well, how are lawyers going to use chatbots? And, when I was kind of getting into this in a lot of different ways and looking at chatbots from all kinds of different directions, one of the things that I saw a few things about is, well, this is something that can really either replace or dramatically enhance the skill sets of paralegals, right? You can take a lot of work that takes a while to do and do it really, really quickly. You can take, contracts that need to be drafted that were tedious, particularly if you were actually trying to write them from scratch, and you can make them, nearly instantly just by filling in details. You can use the chatbot to actually interact with the client and, and get information from them, and at a minimum get to the point where it's at least thinks it's formulated what the issues are, how to respond to those issues, and maybe even drafting that into a contract. On the other end of the spectrum, when you start thinking about criminal law, what about looking at every best closing argument that's ever been made, make something that takes elements from the best and avoids the elements from the worst. I come back to Johnny Cochran, an incredibly successful attorney, and I mean, just some of the things that his firm came up with, in the O.J. Simpson trial. I still remember this: if the glove doesn't fit, you must acquit, right? That's brilliant. How many jurors went into that room thinking if the glove doesn't fit and they showed that the glove didn't fit, that was what they needed to do? And again, strategies like that, looking for things that are very successful throughout the whole of trying to convince people, to go in one particular direction in the case of a jury or not, or to do something else. You can draw from that incredible body of knowledge. And again, big data is the perfect thing to do that within chatbots, maybe the mechanism by which to do it. On the other hand, you have another great question, which is, do we want chatbots practicing law? Right now, the answer is really no. I mean, you get into the question of even like, are they breaking laws by trying to practice or kind of practice laws? And, we have a similar question, arguably, with some paralegals where, sometimes as a client, you may call a law office and you may not talk to a lawyer, but you may get certain legal services provided that maybe should have required, passing the bar, getting a license, little things like that. But they didn't, right? Because certain paralegals get really good at their jobs, and there's a little bit of gray area here. I think there are a lot of people that think in some cases maybe it's not in the gray anymore. Somebody's stepped over the line, but we know that it happened. So, thinking about how a chatbot might be involved in that aspect as well. And again, there's just so many different directions that we can go. So I won't take any more time here because I want to, make sure we get to everybody's questions, and of course give Nicola a lot of time to talk too. But that's the stuff that really excites me about this topic.
Thank you, Professor Datsov. I'll turn it over to you.
Thank you, Andrea, and thank you, Jeremy, as well. Appreciate the introduction. Andrea, I particularly appreciate the shout out to your alma mater, since after Sean's comments, I wasn't even sure if I could mention where I'm attending from today, but I'll just leave it at the vague sort of reference to the university up north. So thank you for having me. This is such a really wonderful conversation to include on this topic, because I think, as we've heard through the comments throughout the day, there's a lot of sort of disruptive changes that are happening with this technology. There's a lot of really exciting things that we can look forward to. There's some scary things, but all of that is really sort of controlled by the law. Right? The law dictates what we can and can't do. It's not static. The law changes all the time. And so that's the good news. We get to decide what we want the law to be. I think I'm happy to kind of talk about some of the more specific sort of uses of ChatGPT that are happening in the law. And particularly, I've been in a couple of those conversations in the context of higher education recently. I sort of thought I might start at a broader level about AI and ChatGPT generally in the law. And, those are the questions that I most often sort of tend to get, is about the intersection between AI and legal issues, which I write and research about. And the first one is, what are the legal issues with regard to AI? And that's a hard question to answer. It's a bit like asking, what are the legal issues in the law? Which sounds a little silly, but I think is accurate. And I realized this a number of years back when I was in private practice, and my firm was looking to start one of the first kind of AI practice groups in the Midwest. And we were having a conversation about it. Well, is AI really a practice of law? Is this, corporate law? Is this immigration law? Is this intellectual property law? Is it tort liability law? Well, what is it, right? Or is it an industry? Is it affect certain technologies, certain kinds of industries more than others? And what I realized is that law is everywhere in the law. So my answer to what are the legal issues in AI is, it's all the issues we've already been dealing with. I think that's really about as accurate answer as I can give. Now, I do think there's a couple of qualifications to that. First, those same legal issues are coming up in a very new light. And I'll mention a little bit more about that in just a second. And I imagine our conversation will touch on that as well. And I think that's important because we've got, in many ways, the same problems, but in a very different context. And so we're going to need, I think, different solutions, at least for some things. The second thing that I think merits qualification to, it's everywhere, is there are some questions that are more important and pressing than others. In my view, I think some of the more important questions from a legal side, not from a policy side necessarily, but from a legal side, center on liability, protection of innovation, discrimination and bias issues, and privacy. Again, those aren't the be-all, end-all of the questions, but I think those are some of the issues that I most often sort of see repeated throughout legal issues that come up with AI. So once we've kind of talked about, what are the legal issues in AI, the next question usually is, well, is the law equipped to handle all these issues? Do we have what we need from a legal side to be able to regulate, to control what's happening, and to feel comfortable in how AI is progressing? And I wrote an article about this in the Dakota Digital Review, which is a wonderful publication. You can find that online for free. And so if you want to read it, look away. Here's your spoiler. Is law equipped to handle AI? Mostly. I think it is, but we've got a lot of work to do as well. There's some folks, some of my colleagues in the law, who argue that AI really just presents no new issues in the law. It's just the same things recycled in a new way. I think we've heard some flavor of that today about the technology, right? It's a new disruptive technology, but in many fundamental ways, it's not different. I do agree to some extent with that, and I agree to some extent with the legal side of it, that we've already faced these problems. What's changing most, I think, than anything else is the actor. It's not the problems. The problems are similar to what we've already dealt with. It's just that something else is doing the action now, right? So for example, if you're thinking about a car being operated by AI, it hits a person. There's going to be liability against the AI manufacturer, right? That's not a different question. Recently, I was on a panel about the impact of ChatGPT on higher education. And someone asked, well, is it ethical if ChatGPT does a bunch of the work and then submits it as the assignment? And the answer to me is easy. No. Whether it's your sister, whether it's your parent or your cousin doing the homework, or whether it's ChatGPT, it's not your work, right? And so again, similar problem, different actor. When ChatGPT generates something that infringes a copyright, and then you take that and use it, you still have some liability, and probably ChatGPT does too. So to some extent, I think the law is where it needs to be. It's doing what it's supposed to do. We've got a very good framework in the legal system to work with. But as I mentioned, a lot of these questions that are coming up with AI are coming up in a new light, in a new context. And as I tell my law students, small changes in the facts can have huge impacts on the result and the outcome. And we've got a lot of new facts that we have to work through. It'll take some time. It's going to take some effort. And as we heard from a few other panelists today, there might be some growing pains to go with it too, because we're in a time of uncertainty. So I think we're going to have to work through that, and I'm happy to kind of give some more examples and go into the conversations and whatever be most helpful, but I'll stop there with my introduction.
Thank you. I'll actually start with the first question directed to you, Professor Datsov, and it is, what advice would you give to non-attorneys about using resources such as ChatGPT as a substitute for hiring professional legal advice or a licensed attorney to, for example, draft a contract or a will, or even a marital termination agreement, et cetera?
Yeah, well, good question. My advice to you is get an attorney. And that's, there's a good reason for that. I mean, we've got some issues in terms of access to attorneys, particularly in rural parts of our country. And that's a real problem that the profession is continuing to try to deal with. And we've got a lot more progress to make there to make sure that people have access to attorneys at a reasonable price. That being said, the quality of what you're going to receive in terms of a work product for legal answers is going to be what you pay for, right? The old adage of what you get is what you pay for. And so in this situation, I think if you're looking to take some shortcuts, you're going to ask ChatGPT, and ChatGPT is pretty careful about this, right? So I don't know that ChatGPT is going to start doing your legal work for you. But it'll come with a lot of disclaimers, and the law changes. The law is specific in different jurisdictions. And so to the points earlier that I think Sean was making, you've got to know what questions you're going to ask it. You may be getting an answer to a question you didn't even think you were asking, right? And that's going to require some expert understanding of the issues. The law is complicated. And so ChatGPT, at least in its current sense, isn't really set up well to do that. I think as Jeremy was mentioning, some of it is viewed as potentially replacing some of the things that might be sort of a lower level sort of a knowledge requirement in the law. So some of the work of paralegals and perhaps preparing forms and those kinds of things, preparing first drafts, some of that might become more automated. I saw an article just recently where someone talked about drafting patent claims based on artificial intelligence. And they said, it does a good job of getting the basics right and a horrible job of all the details that really matter, which is creating the novelty, right? The innovation of what's new in the patent. So if you're going to use artificial intelligence sort of as a tool to help answer legal questions, that might be helpful. It might allow you to find information more quickly. It might allow you to better understand the information at a higher level. But at the end of the day, in terms of exercising judgment about not just what the law is, because that's just the beginning stages. I mean, and I try to really explain this to my students. And law students very quickly learn. Knowing the law is a very small component of being a good lawyer. Knowing how to apply the law in the facts is really where you can make a difference. And for that particular function, I don't think ChatGPT is quite there. And frankly, I don't think it's even trying to be there at the moment because it realizes how much liability there is.
Thank you. While folks in the in-person audience are kind of coming up with their questions, raise your hand, but I'll first turn to a question from the Zoom chat, a Zoom Q&A. It says, earlier, it was discussed that politicians have little knowledge of technology. Is there a way we can better pair legislators with field experts, such as engineers, et cetera, to make better informed policy? I'm aware that, for example, some lawyers going into fields take some science and engineering classes so they know what they are talking about. This isn't a new issue, but a growing one. I remember seeing sitting senators in hearings not understand how the internet works.
I mean, I guess I can go start. I mean, I think it is a real issue. I mean, and it's not really tethered just to the law, right? It's tethered to, a broader understanding of, making decisions about technologies you don't understand. I think there's a lot of things that can be done. Certainly, there are examples of, ways to get people that are going into law more education. Patent attorneys, for example, have to have an undergraduate degree in an area that they could practice in, as a patent practitioner. You can't, just go get an English degree and go on and get, be a patent practitioner the way you could in other areas of law. But I think even that is it's not really a complete answer, right? I mean, you're talking about how do you give people that we're asking to make regulatory decisions that, really affect the technology, they affect the individuals that are using the technology, they affect, investment in the technology. I mean, this is a big thing, right? And so how do you give them the skill set and the knowledge and the understanding to actually do that? And I think really one of the only ways you can do that is kind of like what the person that asked the question says. You have to create a mechanism to get the experts in front of them. And I had an opportunity, I think it was either at the end of last year or earlier this year, to actually present at the North Dakota Judicial Conference, where judges from around the state come and they pick topics, and they invited me to talk about cybersecurity and one or two other kind of related topics. And there were just a lot of cool questions, right? And so we spent, I don't know, however long it was, an hour and a half, 2 hours, something like that, just talking about stuff that they've seen in a case, or they think they might see in a case, or that they had read about in a case somewhere else, and trying to answer questions when there wasn't really, it wasn't an adversarial situation, right? I mean, that's the challenge that judges have, is you have a lot of people in a courtroom that have answers, but normally they have a particular answer that they would like the judge to subscribe to, right? You have two competing parties. One of them's probably not going to win. That's how it works most of the time. And so giving, whether it's attorneys, whether it's judges, giving them access to technical resources that are not aligned with a particular plaintiff or defendant in a particular case. I think that's a big thing. When you start getting into like the legislature at state level, federal level, et cetera, creating a variety of different advisory boards. And so there's a number of different programs that take people from universities, take people from other settings, take people that have hands-on experience working in a particular field, and bring them to a location, whether it's Washington, D.C. or a state capital, and say, come advise us for a year or for 2 years or for a few years. And that's another great way of, again, bringing people in that, I mean, again, everybody's going to have their take on things, right? I mean, nobody typically comes at things totally neutral, but at least it's not, it's not as an advocate for one party in a particular transaction, whether that's trying to get a law passed or a legal case. So I think that's one way. But again, I think it's a real problem. And I think that's a great question.
Thank you. Do you have anything to add?
Just briefly, just to emphasize what Jeremy was saying, and to highlight the important point of the question, that I don't think we want to try to just make the legislators and everybody else an expert on AI. I think, as the question sort of suggested, we want to pair the legislators with the experts. And as Jeremy pointed out, I think that's the better way. I mean, just some of these things are so complex that there's a lot of context involved. And so I think there's lots of ways that we could do that. I mean, I think mostly it has to be surrounded by understanding the issues and starting the conversation so that people understand what is at stake. There's I've been writing more recently about kind of the issue that we don't have a definition of artificial intelligence. We don't. There's been different definitions presented, but there's no universal definition of artificial intelligence. And it means different things. It means different things to those working in the STEM fields than it does to those working in business or marketing. And there's been, on the federal side, at least, I've seen some attempts to define AI in various kinds of acts. And there's been some scholarship that criticizes that essentially the regulation was either too broad or too narrow. And most of what that comes from is the fact that it was poorly defined at the legislative level. And so conduct was either being regulated that they didn't think would be regulated by framing it as AI, or it wasn't really capturing what it was intended to be regulated. And so unfortunately, we need to have a very good level of precision when we're drafting those kinds of laws. And to have precision, we require information and understanding.
Thank you. Yes.
But so in the previous discussion on policy, it has been discussed by the panelists that policies are usually very slow. So are there any like current legal cases related to AI that are going to have law to AI, maybe small or big, that we
Okay, so just to repeat the question, help me if I got it wrong. As indicated in previous sessions, it was mentioned that both policy and law are kind of slow to evolve and come about. But are you aware of any current legal cases that are related to AI that may significantly impact the law? Did I get to your question? Okay. Are you aware of anything in the works?
Sure. So again, the law is impact, or AI and law intersect in many, many ways. And so the areas of law that I mostly focus in on are with regard to tort liability and with regard to intellectual property, mostly focusing on intellectual property. And so in that front, there's been a lot of conversations about innovation. And what is AI doing for innovation? Both, how do we protect artificial intelligence innovation, meaning how do we advance AI, right? Because, and we've talked a lot about what AI is doing, how it's innovating it, and some of the reasons for incentivizing AI research. How do we do that? But at least under our patent system, there's an underlying concept there that we need to provide a monopoly right in order to incentivize further the innovation in these kinds of fields. And right now, there's a lot of conversations going on. There's been proposed legislation that's going to change what things are eligible for patenting. And so I spent a lot of my time following that case law is what's going to be the impact based on how broadly or narrowly we allow artificial intelligence to be patented. What's going to be the impact to the AI innovation life cycles and the investment that companies are putting into it. And there's a few cases that I can mention there that are sort of in the works right now. There's one that's currently being considered potentially as being taken up by the US Supreme Court, but that's a hot button topic with a number of cases. Another area where some questions have come up, and there's a few cases really that have sort of started to, one involving Facebook and a few others in larger parties that have come up, is with regard to data protection. So I know this has come up, right? But data is sort of what allows AI to work. It fuels AI, at least the more sophisticated systems. And that data has an incredible amount of value. And so in what ways do we protect that data? That's a huge question right now that's not necessarily being addressed. More so in some other, again, kind of IP focused questions. There are a number of important cases, one that just made its way to the US Supreme Court. They haven't taken it yet, but that's being briefed on the question about whether AI can be patented, something that's generated by AI, whether that's deserving of patent or not. A similar sort of conversation is happening on the copyright side. If something is generated, a copyrightable work generally is generated by AI, can that be copyrighted? Or is that just essentially going to fall into the public domain? What about if the AI worked in conjunction with a human to create it? So there's some line drawing that's going to happen there on some of these important questions. Tort liability, same thing, right? There's lots of cases so far that are exploring the line of how far are we going to extend liability to products that involve some kind of automation, and when they cause harm. And I think for the most part, what we're seeing is there's still going to be liability for most of the things, but there's some question marks, and particularly where the question marks I think are, or the gray areas are mostly, is when AI involves only software rather than a hardware product. So if it's a hardware product, you're more firmly based in products liability laws. If we're dealing with a software, there's an unresolved debate as to whether software constitutes a product, meaning that strict products liability would apply, or whether you have to rely on other sort of legal concepts there. And those questions are still kind of working their way through the system, and I expect will be for a little while.
Do you have anything to add?
Well, I think at this point too, we're looking, I mean, there's a lot of areas that just haven't been touched. And so every case potentially could be important. And, one of the things that always fascinates me in reading judgments is that sometimes you have something in there that, really, I mean, either, somebody was cleverly crafting it into the decision because they wanted to talk about something, or it was kind of a secondary issue, but yet now the Supreme Court or state Supreme Court has spoken on a topic because it's in a judgment for something else. And so we may very well have cases that are not that, they don't seem that significant, but they end up actually touching on an area that just doesn't have anything in it, right? I mean, this is new stuff. We're talking about, a system of law that goes back, I mean, literally hundreds of years in codified form, and then goes back on, human perceptions of, how we should interact that go back basically, to the beginning of human existence. And now we're taking it and we're trying to change it. I mean, a lot of people don't realize, even like in the United States, our law actually goes back to British common law. And so if something isn't answered by statutory law, there's a whole sequence of things. And if you run out of other places to look, you end up looking at British common law at the time that the United States was founded. So there was a really interesting case. It involved a individual in Michigan named Jack Kevorkian. He assisted in suicides, and they tried going after him case after case after case under a new number of different theories of law. I believe they even passed a law to specifically try to stop his activities. And if I'm remembering correctly, I think that law was found to have constitutional issues. And finally, a district attorney in Michigan said, you know what, we're going back. We're gonna try this under British common law as the ultimate fallback. And it gained national attention because Jack Kevorkian went into court dressed like a British lawyer around that period, which of course was great for those 30-second news bites all night of showing him mocking the fact that that this had happened. But when you think about a framework, about a system that has evolved but built upon these foundations over time, and now we're asking it to deal with concepts, and like some of the things that Nick just mentioned, about is a work that doesn't involve a human actually something that is that is a work that could be copywritten, right? That if you look at like how we determine how long something is going to be copywritten, we have a different way of dealing with humans versus things that have, say, corporate authors, but we still look at it as innovation that comes from a human. So if we don't have a human involved, how does that dealt with? And I would make a slightly different argument, I think, in regards to this, which is I would call it a derivative work, meaning that if I make an AI system and my AI system goes off and writes a neat novel, it's mine, right? I mean, it's just like, I'm not going to give Microsoft Word credit because it autocorrects something. This is a really, really advanced autocorrect. And I think there's an entire different theory that works in patents, that works in copyright issues, and also even just for questions of acknowledging authorship, that the people that actually make the AI system that goes and creates this thing, as well as, places where data comes from, you could have a very complex authorship or invention question. And that's something that, again, you get into a different type of question, but it's not the question of, is there no author? It's a question of, okay, now we have like, 1,000 authors because we have a few people that made an AI system, and then it read, 500 works, and it took a little bit from here and a little bit from there and whatnot. And like we were talking about in the panel earlier about design, we expect people to learn from what has come before, but we also, at some point, also expect them to cite certain works, and exactly where that line is drawn, is always something that can be a little bit difficult for people to understand. Sometimes somebody will think, oh, well, this is so common that it doesn't need to be cited, and somebody else will see it and say, wow, that's my great idea that you've just taken and used without giving it credit. So I think we'll see issues like that as well. But again, there's so many different ways of looking at this stuff, which is what makes it so fascinating.
Okay, so I have another question. Could you expand on intellectual property issues if from the perspective of a business practitioner, someone on the board, someone who is running ABC Incorporated, and maybe their marketing department is deciding to go off and try to use some of these resources? And could you kind of speak to the business professionals in our audience to what things that they might need to be aware of, liability issues, et cetera?
Sure. As we get into these, I have to throw out the disclaimer, right? Is never sort of take any of these discussions as a substitute for attorney legal advice. We're just having a general discussion in terms of concepts and issues to think about, but how it applies to your situation is obviously unique, and you should definitely consult an individual with a license rather than a robot to get some advice on how to deal with them. There's a lot. So again, it depends on how you're using the technology, really where I think your focus should be. So it's a little bit hard to answer in the abstract in terms of what issue to be aware of, because it could be everything. So I'll just mention a few that oftentimes have come up. If you're using automated technologies with regard to hiring, with screening any kind of applicants, for example, you need to be aware of employment discrimination laws, right? That those laws still apply because you're, the company meaning, acting in a way, right, to screen applicants using, at that point at least, a tool. AI is not going to hire somebody for you. It might help you screen some information, might help you filter applicants, et cetera, et cetera. That process is still governed by applicable laws. And so if you're using automated technologies to reach some of those decisions, you need to think about whether you're complying with employment laws. And in some ways, this has come up again. There's no shortage of sort of nightmare stories where there's been evidence that AI models, because of the data they were trained on, have evidenced a bias in certain situations, right? I think Amazon was one that used it, and I think shut it down because of gender bias issues that it demonstrated. So if you're doing that, you just need to be careful about that. If you're having your employees use any of these kinds of automated technologies to help them with their research, for example, whatever that might be, understand that once you type it into, for example, ChatGPT, you've lost confidentiality, or you might have lost confidentiality and privacy. Right. So if you're going to type in individuals' names, do you have the right to disclose that information? In the software sector, for example, and I've got some of my friends who are computer programmers, and they deal with this all the time. I've known of situations where companies, engineers will sort of post information and say, hey, we're trying to do this with our code. Does anybody have any ideas about how to do this? Some of that information may be a trade secret. It may be protected beyond just confidentiality. Once that information has been disclosed and is now public, it may no longer be a trade secret. In fact, that's how trade secrets lose their protection, or at least one of the ways they can lose their protection. So if you're taking confidential information and sharing it, for example, with ChatGPT, that could be a significant issue. If you're taking information from ChatGPT and putting it into your own systems, right? The reverse of that situation where you're asking ChatGPT, you're thinking, I'm not giving it any information. Everything I get is just a bonus, right? Well, if you take that information, particularly if it's computer code, for example, and you integrate that into your own system, do you have permission to do that? You shouldn't just assume that whatever ChatGPT has given you, you have a license to use. And so in a more common example that has come up in the past in this situation is for companies that develop software. If you take open source software and incorporate that open source software into your own technology, by the license terms of some of those open source technologies, you may be making your own software or whatever product you're dealing with open source, right? And so you have to think about what information your employees are getting, where they're getting it from, even though it might be generated, right? ChatGPT is generating it from somewhere. And if it's taking it from a source that has not licensed that particular issue, whether it's art, whether it's protected information, whatever it might be, if you're taking that and you're incorporating it into your own technologies, it doesn't mean just because you are attributing something, for example, to say, we've got this from ChatGPT or wherever it might be, that you've met the requirements. Attribution and permission are two very different things. And so, and both potentially could land you in hot water under the law. So there's probably more examples that I can go in. I don't know if I'm answering the question exactly, but the big takeaway I would say is be really careful. And it will be probably most prudent if you're doing enough, or if there's enough at stake, to really make sure you talk to a licensed and competent attorney about what you plan to do, at least to be aware of the potential issues that you could be walking into. And then you can make informed decisions and to say, well, we're not really worried about this. We're not worried about the employment factor. We are worried about this open source software thing. We're worried about privacy, et cetera, right? Whatever your business is, it might be impacted differently.
So I might throw it back as a question as opposed to an actual response to that. I think there's two kind of interesting questions here. So I would be curious, Nicola, to hear your thoughts on the role of fair use in how ChatGPT sources stuff. Obviously, like when the open source question, if fair use doctrine applies, it doesn't really matter what the terms of the copyright are, unless you've agreed to the agreement. If you're just grabbing it, there's a fair use doctrine argument there. And then I guess kind of tangentially related to this, I don't know if you're familiar with a company called Nolo Press, Nolo. They make self-help legal books, and they got themselves in some difficulty with I think it was a bar complaint actually about practicing law without a license for writing these books, and I believe they prevailed in that, if I remember correctly. But kind of thinking about the two thoughts that you've just had about that, do you see those as factors that that you would consider, or does that really not change the calculus when you're looking at those questions you just answered?
Yeah, and that's a great question, or a couple of great questions. So let me touch on the first. So the concept of fair use is fuzzy at best. Just for those of you that aren't quite contextually as familiar, essentially when you have material that's copyrighted, and it's a fairly low bar in terms of what's copyrightable. But once something's been copyrighted, and that has a very broad meaning. It's any artistic work essentially that's been put into a tangible medium. You don't have to register it with the Copyright Office for it to be protected, right? If I sit down on my computer and I write down a letter to Jeremy today, that's potentially very likely copyrightable, okay? And it's copyrightable or copyrighted at the time that I've written it. I don't have to register that letter. If someone were let's say there was something, really valuable in there, or let's say maybe as a simpler way to kind of eliminate the information piece of it. Let's say I draw something, right? As soon as I've drawn it, that is subject to copyright protection. I can't file a lawsuit yet because that requires registration, but it's protected. If someone were to take that or use that drawing without my permission, it's essentially going to be a very strong case for copyright infringement. The caveat to all that, the most powerful defense there is to the use of someone else's copyrighted works, as Jeremy has alluded to, is fair use, meaning my use is fair and I shouldn't have to pay you for it. I should be allowed to use this copyrighted work because. And there's 4 factors that balance whether something is fair use. Probably beyond the conversation, I spent several classes in my intellectual property course with students. It's complex. And even the US Supreme Court most recently has kind of started to look at the doctrine again. There's been a number of cases. There was a big fight between Google and Oracle that some of you may be familiar from a couple of years ago. There's been now the Prince Estate versus Warhol sort of cases up at the Supreme Court. There's been iterations of different contexts in which fair use comes up. And I think the focus oftentimes tends to be and this is one of the things you can consider, is there a transformative use of the copyrighted work? Meaning, have you changed something about it, or are you just merely replicating and using it? And there's nothing that's dispositive. There's no one thing that's going to be dispositive on these issues. So you kind of have to look at it holistically, which makes it difficult to predict what exactly is fair use. So do I think fair use will play a role in some of this? Absolutely, I do. But it's also important to remember that the use of whatever copyrighted material we're talking about, whether it might be data, whether it might be drawings or art, whatever it might be, the way that ChatGPT or some other automated technology is using that might be different from the way that you use it. And just because you merely acquired it from somebody who might have had fair use to use it doesn't immunize your use of it as well. So I think there's an important distinction to be made there. And then Jeremy, what the second question that you had asked, I want to make sure that I'm answering it correctly. What was that with regard to?
Yeah, so I was just, when you were talking about the question of the, chatbot acting and providing some sort of legal services, how you thought that, that would relate to, again, companies like Nolo, the self-help law books, and even, even maybe a step beyond that, some of the places that do like the, packaged forms where, they give you a form and they say, fill in these 6 things and, you have an agreement at least, and maybe it's not a great agreement, but, where would you see ChatGPT falling on the spectrum, or something else like ChatGPT falling on the spectrum with those things, both in terms of, is it practicing law without a license? And then also, would you feel comfortable using it for certain things, and under what circumstances?
Yeah. So, I mean, I think I'll go in reverse. I would feel comfortable using it in some ways. And again, I would say I would feel comfortable in using it as an information gathering tool. It's no different than, at least at a core level, with the way you might use Google, right? You go on Google and you might ask a question, and granted, those are just responses that it's aggregating rather than giving you a response. But in some ways, that's essentially what ChatGPT is doing too. So if you're using it as an information gathering tool, I think that that's probably okay. Although disclaimer, right? And I think ChatGPT would give you the same disclaimer, is you have to be careful, because sometimes it has erroneous information too. That has happened in some instances. And again, the law isn't this uniform thing, at least unless you're talking about federal law. State laws vary. And so if I'm asking ChatGPT, what are the elements of this particular law, that might vary, again, depending on whether I'm asking it about Minnesota law, North Dakota law, or California law. So I don't know to what level of sophistication we can trust that even. But if you're just asking broad questions, in most things, you can probably get a decent answer. So that's probably okay. If you're asking ChatGPT to draw judgments for you, how does the law, those elements that I've just found, how do they apply to my situation? My understanding of ChatGPT right now is not even going to tell you. It's going to tell you, I can't answer that question for you. Go get a lawyer. I've heard there are some ways to kind of play with that and maybe get around it. But that's probably not a prudent thing to do. And I think that's where I see it sort of as a different sort of problem than the ones you've mentioned, Jeremy, about, the tools that just allow you to create a will or allow you to create a basic contract, or what sometimes companies and people do, which is not great in my opinion, which is just go download a form off the internet, right? And that's how you end up with, here's your condominium rental agreement, which was modeled after, can I borrow a tiger for the zoo, right? And it doesn't work very well. But ChatGPT is a little bit more sophisticated, and those forms can be a little bit easier to aggregate. Importantly, I think their terms of use of service usually say, we're not practicing law, we're just giving you information, and then you can make your own decisions, right? They're a tool. ChatGPT can be used by more than that, and people might falsely think, oh, this is great, I'm actually getting helpful, competent advice. When the reality is, even if you do get that, that might not be what you're getting.
Thank you. I'm going to take or read a question from the Zoom Q&A. The question is, there was a story about AI being used by corporate lobbyists to better influence and fund senators and draft favorable laws. In a political system that is already much too influenced by corporate special interests, how can AI be conversely leveraged by the people to affect an equal change and reduce this disparity? You want to take that first crack?
That's a big one, right? All right. So how do we change society using an AI tool? All right. So I hope nobody was planning on going anywhere for the next, I don't know, 20 or 30 years. It's going to take a little while to answer. No, it's a very big question. How, I mean, you have a really big issue when you're talking about, the powers that come to play when these types of things. And, what could you do to try to leverage those from the perspective of individual people? I think that's difficult, right? I mean, you really have to look at that on kind of a case by case basis and what you're actually trying to accomplish or prevent maybe from that. And, I mean, I think one area that it could be helpful, we've seen a lot of promulgation of misinformation by electronic tools. And so could you use it to convey an accurate campaign, but with nuance, right? Have lots of different places. You could use something like ChatGPT to respond to threads, to try to provide accurate information, to combat misinformation, or to just provide accurate information at any place where that information may be relevant. I think that's one perspective, one place you could potentially use that. And again, there's also really significant potential for misuse. When you go back into the questions of, Russian involvement and others' involvement in our election in 2016, it wasn't ChatGPT, it wasn't necessarily even a language model exactly, but the technology is really similar. And, if you're talking about the speed of a human versus the speed of this bot that basically doesn't sleep, doesn't eat, and can type a lot faster because it doesn't have to actually use a keyboard. There's a lot of power there. There's a lot of power to get the message out. And I think Todd was saying in our past panel, the ability for these systems to actually emulate to an almost undetectable level being a human, who do you really know? Who do you know? How do you know who you're actually talking to? And so if humans are interacting with this wealth of information that's responding saliently to every point, it may not be right, but it certainly is going to take the right perspective if you're set it up to do that. That's a very, very powerful tool. It's messaging that's pervasive, that's individualized, and again, it's shown to be very effective. So I think if somebody wanted to use the technology as a way of being the little guy fighting the big guy, that would be a way you could do it. I think there's a really big ethical consideration here to, at a minimum, make sure that when the way you're using the technology, you're at least being accurate, right? That, I mean, I think if you have a mechanism that's out there that is providing the correct information and just providing a lot of correct information, particularly when you're dealing with a opponent that has a similar ability to project message that you don't, that to me seems like it would be okay. I think you run into some questions about, a plethora of interference issues and, questions about maybe even misrepresenting, who is interacting that need to be dealt with. And we may have campaign finance questions here. We may have, a slew of questions even ranging from, Bill of Rights questions about what is protected speech and what isn't. But that would be one way that I could see the technology being utilized in kind of the David versus Goliath battle to benefit David.
Do you have anything further to add?
No, I agree. I think it's an important question. I mean, I think there's a couple of different ways that we can use it, but it all centers on what Jeremy talked about, which is that it could be an equalizer in the leverage, right? So a lot of times those who look to influence the lobbying efforts have a lot of resources behind them, and AI can help aggregate information, can help analyze information, and so it allows fewer people to do more with less, essentially, right? And so if you're able to use AI, already existing algorithms, already existing models to analyze data, you can present those findings and better support your argument, better support your side. But I think the other one is that AI can be used to better analyze what issues are going on. What are some of the most pressing concerns based on what we're seeing in the discourse online or elsewhere, to highlight where the problems are, right? Because there's a finite number of resources in the legislative sectors that can be utilized in any given session. And we can use AI technologies to say, we're really focusing on the wrong things. We should be focusing more about this because this is having a larger impact.
Thank you. There's a question in the live audience.
So it's well understood that tools like ChatGPT or any type of generative AI tool have great potential for dangerous or nefarious types of activity. People might want to learn how to poison drinking water, or build a bomb, or construct a power grid, things like that. So, at a level of sophistication never before seen, really. So I guess the question is, are the laws that we have now about monitoring activity like that, penalizing activity like that, or disrupting activity like that, adequate? Or do we need a generation of regulation that deal with this ever more sophisticated way to do these dangerous things?
Thank you. So the question is, considering ChatGPT and other AI tools, and they have great potential for people to engage in potentially dangerous and nefarious activities such as contaminating drinking water, bomb making, disrupting power grids, etc. The question is, are there laws in place, or do the laws that we have in place regarding monitoring and penalizing adequate to address the sophistication of these tools?
So just to make sure I understand the question, are there laws in place to adequately address the information that people can gather from ChatGPT? Is that kind of the question?
Yeah, I mean, one could easily envision that there should be laws and regulations that are in some way designed to, curb the potential danger of activities like this, and is there a need for new laws, new regulations, new monitoring, something of that sort to help prevent that kind of thing?
So the question is more along the lines of, do the laws and regulations that are in place, are they adequate to curb the dangerous activity? And I have a question just so I can clarify. Are you talking about surveillance and monitoring, et cetera?
Yes, sure.
Okay, so we can maybe even talk to Dr. Straub about his thoughts on privacy.
Yeah, so I mean, I think that's an interesting question. I mean, I think there's two parts to it. I mean, I would argue, yeah, we do. I mean, we clearly have laws about, don't contaminate people's drinking water. We have laws against don't blow things up. I don't think we necessarily need to specify how, which ways things should not be blown up. I think we can say, that's more of an impact question than a mechanism question. The only place where you really get into a question of the mechanism is intent. So if somebody does it by accident, if you're asking Alexa to turn on the light and inadvertently you turn on something else and that causes an issue, I think it'd be very difficult to say, hey, that formed criminal intent because the system didn't do what it was supposed to do. But I don't think we need a special law that punishes people for misusing Alexa. Where I do think that this could be very relevant is as a sentencing enhancement. We have, in federal sentencing guidelines in particular, but also in state law, we have different things that make crimes more severe in terms of the punishment. And, when we hear about all of these, every time you hear something on the news where, everything, you hear these great, that this is punishable by 20 years, 50 years, whatever, those numbers that they use on the news are normally the maximum, right? Because that's what gets people excited on a news programming is, oh, this person's going to spend 20 years in jail, and then you find out they got a sentence of like 6 months because they had never had a prior offense that wasn't the most extreme form of the crime. Could we say, if you use a technology like this to automate it, if you use the technology in some other way, that makes it a more severe version of the crime? I think that makes a lot of sense, but I don't think we need a special law that says, don't use ChatGPT to, do this, which then does that, and then somehow another results in something being blown up. Again, we already have a law that says don't blow things up. So I guess that would be kind of my take. The second part of it, I guess, related to the surveillance question. I mean, I think that's kind of interesting too. How, where would we potentially get information from? certainly if somebody is typing something into ChatGPT that indicates that they may be looking for this type of information, you have a lot of interesting questions there. You have questions about what expectation of privacy does the person have when they're, asking this question. If we even go back to our previous question about using, something like a language model to get legal advice, let's assume fast forward down the road and we've come up with some framework where the system can at least do the work of a paralegal, maybe answer some basic questions where there might be a concept of privilege that applies to it. We have a variety of these privileged relationships and these privileged concepts. Similar, somebody might be getting medical advice and maybe there's an idea of medical privilege. We have exceptions in all of our elements of privilege, usually that prevent privilege from attaching to information that relates to somebody trying to get information to involve the provider in committing a crime. I would think that you would have a pretty good argument for surveillance in that case that would be different from other areas, and certainly, if you're signing a non-disclosure agreement related to, using a language bot, there's a lot of ways you can potentially get into the question of what is public and what is private. But I think there is a compelling argument to be made that if somebody's asking a language model how to conduct a nefarious activity, that that again, maybe it's one level beyond a simple question, but that could allow some sort of disclosure that otherwise might not be allowed. The flip side of that, of course, is people do have to ask these questions for other reasons, right? We don't want the FBI coming out every time somebody's researching a chemistry experiment that might have, an end. Security researchers in a lot of cases have to put stuff into Google to find, things online that relate to current threats. And again, we don't need an FBI agent coming every time somebody, as a student in a security class, puts something into Google that could be indicative of maybe if you combine this with 3 other things, the information that you need to actually conduct a cyber attack. So I think it's a really interesting question. I think it's an area that we don't have great answers for yet in terms of where the bright line is, but we have a lot of things that we can use from the past to help us understand where we think the courts might draw the line, and also to help us understand about where as a society we perhaps should decide to draw the line when we actually do get to a bright line rule. So I guess that's kind of my take on it.
Thank you. Do you have the clarification you needed about the question? I know you don't have the ability to hear it.
Yeah, I do. So I apologize. I just can't hear the questions. So lots of things we could talk about. Jeremy highlighted a few of them, so let me just kind of touch on them because I know we're kind of running out of time. But first, with regard to the question of can someone use ChatGPT in nefarious ways? Jeremy's right. We regulate and prohibit conduct under the law, not the tool that it's used in, right? So we have laws that say you can't stab people. We don't have laws that say you can't use a pencil or a sword or whatever, right, to stab people. It's not the methodology, it's the conduct that we usually regulate. As far as prohibiting access to information on certain areas of ChatGPT, that level of restriction usually is not something that we do a whole lot of in the US. We generally presume that people are going to have a right to the free flow of information that they want to get, and liability is attached based on how they use that information, if at all. The flip side of what again, we've kind of touched on, but there's a much more deeper layer to talk about, is the privacy issue. A lot of people are really surprised, but everything we do these days, if it's digital, you're probably leaving some kind of data trail behind. And people really are surprised to know that there isn't really much protection for that. There is no federal privacy law that exists to protect everyone. There are some, I shouldn't say that. There are some federal privacy laws that protect certain kinds of information, right? HIPAA, financial disclosures, those kinds of things. But there's no federal general privacy law that applies. It's a patchwork of state laws, and so far it's a small number of states that have passed it. North Dakota actually tried to do that, not during this legislative session that I know of at least, but during the last one. And it didn't get out of the committee to enact sort of a consumer privacy protection with regard to how businesses can use information. But what businesses can generally do with things that you've put out there is a lot, to say the least. So if you're putting information into ChatGPT, if you're disclosing some of your privacy into Google, whatever it might be, you're generally letting go of that kind of information. There are lots of other things that I think we could talk about, but I know we're over time, so I'll stop there.
No. If I can jump in for just a second, one quick thought. It's kind of interesting. There's a lot. We hear the idea that North Dakota doesn't actually have privacy laws with some frequency. And Joe Basic and I, Joe Basic is another person at UND. He's actually an attorney in the aviation department, wrote a paper, I don't know, probably 2.5 years ago now, showing that North Dakota actually does have a privacy law, because we actually have privacy provisions in the criminal code. We don't have them in a lot of places that other states do, but we actually have some very severe language in the criminal code criminalizing a lot of uses of information. So I just always like to mention that when we're talking about North Dakota privacy, but want to throw it back over to Andrea because we are out of time.
All right, please join me in thanking our panelists. I appreciate you being with us, Professor Datsov, and thank you again, Dr. Straub.